There are approximately 370,000 homeowner associations operating in the United States right now. Most of them send letters about lawn height. Most of them argue about mailbox colors and whether your holiday decorations are still up 2 weeks past the approved date. Most of them are a mild nuisance at best, a headache at worst. One of them built 97 vacation homes on a private lake. My private lake. And I want to tell you how that happened. Because the story of how a boutique real estate developer turned a quiet Tennessee cattle ranch into a $41 million luxury retreat, using a homeowners association as their legal crowbar, is the kind of story that rewrites what you think is possible in this country. But I also want to tell you what happened after. Because on the morning of September 14th, 2022, a woman standing at the base of a concrete dam in Harlan County, Tennessee, made a decision that drained 97 vacation home docks, triggered a federal water authority inquiry, and eventually found its way to the Tennessee Court of Appeals. That woman was me. And whether what I did was right or wrong, I'm still not sure I can give you a clean answer. My name is Margaret Caldwell. Most people call me Maggie. I'm 58 years old. I've spent the better part of my life on 340 acres in Harlan County that my grandfather, Earl Caldwell, purchased in March of 1951 for $4,200. The whole parcel. Pasture, hardwood timber, a creek that ran along the eastern boundary, and a natural lake basin that Earl dammed in the summer of 1953 through a partnership with the state's agricultural cooperative program. The dam wasn't an engineering wonder. It stood 24 feet tall and 180 feet wide. Compacted earth, concrete core, 2 primary drawdown gates, and a lateral overflow spillway. But it held back approximately 60 million gallons of water and created a 47-acre private lake that my family named Kettle Lake. My grandmother chose that name. She said from the ridge above the property, the water looked like a cast-iron kettle, wide at the bottom, narrowing toward the dam face at the top. For 70 years, Kettle Lake was ours entirely. We fished it in the mornings before the summer heat set in. We swam in it. We watered cattle from the southern bank. We watched 4 generations of children learn to swim in the same shallows my grandfather waded through the year the concrete was poured. My father, Roy Caldwell, operated the dam for 3 decades before his knees gave out. He taught me every gate, every valve, every overflow channel. He taught me the seasonal pressure cycles, the silt accumulation patterns, the maintenance schedule, and, this part matters, the legal framework under which a private dam owner operates in the state of Tennessee. Under Tennessee Code Annotated, under the provisions governing water control structures and private impoundment authority, the owner of a permitted private dam retains full operational control of that structure. Our family held permit number DCS-195-3-0047 from the Tennessee Department of Environment and Conservation. It had been renewed without interruption 7 times across 7 decades. My father said, "Know your permit the way you know your fence lines." I did. I just never thought I'd need to use that knowledge as a weapon. The first time I heard the name Pinnacle Shoreline Development, LLC, was the fall of 2017. I was at the Harlan County Assessor's Office for a routine boundary check, something I did every few years on the eastern edge of our property, where a gravel access road ran along the state timber boundary. Standard due diligence. My grandfather taught my father, and my father taught me. Know your lines before someone else redraws them. The clerk, a young man named Teddy Marsh, who I'd known since he played third base in the Harlan County Rec League, looked distinctly uncomfortable when I walked up to the counter that morning. "Ms. Caldwell," he said, setting his coffee down slowly, "you might want to look at the new plat filings on the north parcel." I didn't know what he meant by the north parcel. That wasn't language I used for land I'd walked since childhood. But when Teddy unrolled the plat map on the counter, I understood immediately. What I was looking at was a proposed development called Kettle Lake Shores, with Kettle Lake, my family's 47-acre private lake, drawn at the center as the focal amenity. The plat divided the lakeshore into 97 individual lots, each with private dock rights, totaling approximately 6.2 linear miles of the shoreline. My shoreline. I want to pause here because I know exactly what you're thinking right now, and the thing I need you to understand is that I didn't panic. I didn't yell. I went quiet in a way my father would have recognized immediately. Because in our family, quiet meant the fight was already starting on the inside. I asked Teddy who filed the plat. Pinnacle Shoreline Development, LLC. Registered in Delaware. Principal address, a law office suite in Nashville. I asked on what legal basis they were claiming rights to our lakeshore. Teddy pulled the companion document, a 214-page lakefront easement and riparian use agreement, filed under a recorded instrument number with the county. In it, Pinnacle's attorneys claimed to have acquired a permanent commercial easement over the Kettle Lake shoreline through a deed interpretation provision buried inside a 1978 boundary adjustment my grandfather had signed. I drove home and pulled every document from that 1978 transaction out of my father's filing cabinet. It had been a routine rural adjustment. 1.4 acres of creek gravel bed transferred to an adjoining parcel in exchange for a drainage easement. My grandfather's attorney handled it. No mention of the lake, no mention of future commercial use rights. A standard handshake transaction between neighboring landowners. But Pinnacle's legal team had spent what I later confirmed was $340,000 in billable hours, constructing an interpretation of one phrase in that 1978 deed. The phrase was, "and associated waterways." Their argument was that this language implicitly conveyed riparian commercial access rights to any subsequent developer operating on the adjacent parcel. In plain language, my grandfather had accidentally signed away the lakeshore in 1978, and nobody had noticed for 39 years. That was their theory. By January 2018, Pinnacle had broken ground, not cautiously, not tentatively. They moved the way developers move when the permits are already bought and they don't expect real resistance. 6 weeks of clear-cutting stripped 18 acres of lakeshore hardwood. They brought a site engineer from Knoxville and began laying infrastructure for 97 vacation cottages, each priced between $385,000 and $520,000. They also filed the formation documents for the Kettle Lake Homeowners Association. This is where I need to slow down, because what I learned over the following months, through my attorney, through depositions, through documents we pried loose in discovery, was something I had to have explained to me twice before I fully understood it. The HOA was not formed for the homeowners. It was formed for Pinnacle. My attorney, Patricia Odom, a property litigator out of Cookville who I hired in March 2018, after 3 other lawyers told me the case was too complicated for the likely recovery, laid it out plainly on our first call. She'd seen the structure before. A developer creates an HOA before a single unit sells. They stack the founding board with their own employees and retained counsel. The HOA claims stewardship over shared community amenities, in this case, the lake. Once that HOA has legal standing as a governing body, it becomes an instrument to formalize the easement claim, to create enforceable lake access rules, and most critically, to challenge the private dam owner's operational authority. If Pinnacle could reclassify our family's dam permit as shared community infrastructure under the HOA's jurisdiction, they could dictate water levels to maximize waterfront property values. They could prevent us from performing normal drawdown operations. They could, in effect, conscript our dam into serving 97 vacation homes without compensation, without consent, and without legal recourse on our part. The Kettle Lake HOA's first formal act on March 2, 2018, was a letter to the Tennessee Department of Environment and Conservation requesting that our dam permit be reclassified under the proposed Community Development Plan. They filed that letter 11 weeks after breaking ground. Patricia filed an objection on March the 29th. TDEC acknowledged receipt, then went quiet. By May, 34 vacation homes had walls. I want to tell you about the summer of 2018 because that's when it stopped being a paperwork problem. Pinnacle's sales team had launched a full marketing campaign. Billboards on I-65, drone footage of the lake on every platform, a dedicated website called kettlelakeshores.com featuring sunset photography of water that belonged to my family. They were selling private lakefront living in the Tennessee heartland. They were not disclosing that the lake was privately owned by someone who had not agreed to any of this. By the time Patricia and I filed our first formal complaint in Harlan County Circuit Court in August 2018, 51 units had been sold. Mortgages financed, families making plans. Those people had no idea. Here's the part I need to be honest about, because those buyers were not Pinnacle. They were ordinary people, retirees who had saved for 20 years, young couples who thought they'd found something real, their families who wanted a place their kids could remember. Some of them had already started drawing up dock plans. And what I was doing, what I had to do, was going to complicate their lives in ways they hadn't signed up for. I've thought about that a lot in the years since. I'm still thinking about it. Our lawsuit, Caldwell versus Pinnacle Shoreline Development LLC et al., rested on 3 claims. First, the 1978 deed language was legally void as a riparian rights transfer. And associated waterways was standard boilerplate from a county deed template, not a specific conveyance of commercial lake access. We had a sworn affidavit from a retired property law professor at the University of Tennessee confirming this analysis. Second, the HOA had been formed as a fraudulent instrument of the developer, not a genuine community governing body. Tennessee law requires independent board elections for a valid HOA. Pinnacle had never held one. Third, permit number D CS-1953-0-047 remained the controlling legal instrument for all operational decisions related to Kettle Lake. Full stop. Pinnacle filed a countersuit in October 2018, seeking $17.4 million in damages, alleging tortious interference with commercial development, and claiming our insistence on dam authority created an unresolved liability exposure affecting their entire homeowner pool. $17.4 million. Against a cattle ranch that had been operating quietly on the same 340 acres for 70 years. The legal process moved the way legal processes always move, slowly, expensively, and with moments of clarity that arrive at the worst possible times. By spring of 2020, 89 homes had been completed. 82 had sold. The Kettle Lake HOA had grown to a membership of 82 real families, people who paid dues, attended board meetings, and had no meaningful awareness that their investment sat on legally contested ground. Our legal fees had reached $312,000. We were not wealthy. My father had passed away in January 2019. He never saw a resolution. I had sold 80 head of cattle to fund the fight. I was consulting part-time for neighboring operations, paying Patricia in installments, and running the ranch alone. The trial was scheduled for September 2020. COVID postponed it. A judge reassignment pushed it to March 2021. Procedural motions from Pinnacle's team delayed it again to September 2021. 3 years. 3 years of motions and filings and invoices and waiting, while the vacation homes kept going up and the development kept selling, and the lake I'd grown up on kept reflecting sunlight into someone else's windows. The 97th and final unit sold in June 2021. $490,000. Shortly before trial, in early 2021, Pinnacle transferred formal HOA board control to elected homeowner representatives. One of several strategic moves their attorneys made to legitimize the HOA's independent standing in advance of the September hearing. And in late July, that newly independent HOA, still represented by Pinnacle's original legal team, filed an emergency motion seeking a court injunction against my dam operations. The reasoning: my annual late summer drawdown, standard practice for 70 years, would lower the lake level by approximately 4 feet and temporarily expose boat dock foundations. They wanted a court order preventing me from operating my own permitted dam. The judge denied it within 48 hours. His written order included one sentence that I have kept photographed on my phone since the day Patricia sent it to me. The court finds no basis for restricting the permit holder's lawful operational activities pending resolution of the underlying property dispute. Pinnacle's team filed an appeal 4 days later, and while that appeal was pending, I received a certified letter from the HOA's property management firm instructing me to cease all dam operations, citing the appeal as sufficient legal authority. The management firm was called HOA Community Management. Patricia confirmed within 48 hours. HOA was a wholly owned subsidiary of Pinnacle Shoreline Development LLC, a developer, creating a community organization, using it to threaten me through a subsidiary they'd disguised as an independent company, with a letter that had no legal standing whatsoever. I want to ask you something directly. When a company fabricates a community organization, claims authority over property it doesn't own, and then sends legal threats through a shell subsidiary, what do you call that? I had several words for it. I kept most of them to myself. My father would have kept all of them to himself and just gotten back to work. I tried to follow his example. It took everything I had. Trial began September 13th, 2021. 4 days in a Harlan County courtroom. I watched Patricia dismantle the 1978 deed argument witness by witness, a historian of Tennessee water law who testified that and associated waterways appeared in a standardized rural deed template circulated across 43 counties in the 1960s and 70s, never intended as a specific riparian rights provision. A title insurance expert who testified that no competent title search in any of the 97 purchase transactions had flagged the underlying ownership dispute, meaning Pinnacle had buried it. The original 1953 dam permit. All 7 renewals, 70 years of unbroken operational history. Pinnacle's attorneys argued hard. They had skill and volume and a great deal of client money behind them. The facts were not on their side. On September 17, 2021, Judge Harold Wynn issued a 38-page ruling. Finding 1. The 1978 deed language did not constitute a valid transfer of riparian commercial development rights. Pinnacle's easement claim was legally void. Finding 2. The Kettle Lake HOA had been formed with procedural irregularities that compromised its independent standing, though the court declined to dissolve it outright, citing the interests of 97 good-faith buyers. Finding 3. Permit number D, CS-1953-0047 remained the controlling legal instrument for dam operations, and the Caldwell family retained full and exclusive operational authority over Kettle Lake. We won. Patricia called it one of the cleaner rulings she'd seen in 22 years of practice. But here is what a court ruling doesn't do. It doesn't remove 97 vacation homes from your shoreline. It doesn't replant 18 acres of hardwood that was clear-cut in 6 weeks. It doesn't return the families of great blue herons that had nested in the eastern cove every spring since before I was born. And it doesn't stop an HOA from treating a decisive legal defeat as a scheduling inconvenience. Within 72 hours of the ruling, the Kettle Lake HOA had sent communications to all 97 homeowners characterizing Judge Wynn's findings as a temporary setback and confirming that an appeal was being prepared. That appeal was filed October 4th, 2021, and every one of those families continued to use the lake, continued to use the docks, continued to motor their boats across my water like the ruling had been a weather event. Unfortunate, but not their problem. By the spring of 2022, I had been in litigation for 4 years. My fees had reached $487,000. I had sold the last of my cattle. I was renting pasture to neighboring farms to generate income. I was being ground down, not by a single dramatic blow, but by the slow, expensive, grinding math of a protracted legal fight against a company with institutional resources. Here is what they don't tell you about winning. You win, and then you wait. You wait for the appeal. You wait for your opponent's team to file motions designed not to succeed, but to exhaust. You wait while the thing you won sits frozen, while someone else continues to benefit from the situation as though the ruling never existed. Then came the inspection notice. Every 5 years, the Tennessee TDEC requires a formal structural inspection of permitted private dams. Ours was due. Inspection was scheduled for September 16, 2022. Required procedure: a drawdown, lowering the lake level by 6 feet over approximately 72 hours to expose the base spillway and lower foundation zone for the engineer's visual assessment. I filed the required 30-day advance notice with TDEC on August 14, 2022. Standard protocol. I filed a courtesy notice with the Kettle Lake HOA on the same day. Drawdown scheduled September 14th through the 17th. Lake returning to normal operating level by September 20th. The HOA responded August 21st with a letter from Pinnacle's attorneys demanding postponement pending a court stay. Patricia checked the appeal record. No stay had been filed. No stay had been granted. The letter was a pressure tactic with no legal foundation. I responded in writing on August 23rd. The drawdown would proceed as scheduled, pursuant to permit number DCS-1953-0047 and the operational authority confirmed by the Harlan County Circuit Court on September 17, 2021. I received nothing further in writing. On the evening of September 13, 2022, I drove out to the dam at dusk and sat in my truck for a long time. 47 acres of still, dark water. 97 vacation homes glowing along the shore, yellow windows, wood smoke from someone's fire pit, the low sound of a boat engine turning over somewhere in the cove. My grandfather's water, carrying the light from other people's porches. I thought about my father, about the cattle I'd sold, about the herons. Then I drove home and went to bed. At 6:47 a.m. on September 14, 2022, I opened the primary drawdown gates on Kettle Lake. Before you decide what you think about what I did next, I need to be precise. The drawdown was scheduled. It was permitted. It was noticed in writing to the state authority 31 days prior. It was noticed in writing to the HOA 22 days prior. It was required under my permit renewal conditions. My dam safety engineer, Charles Breck out of Cookville, was arriving on the 16th. Every procedural requirement, satisfied. What I did not do was mitigate the impact. A drawdown of this scope, conducted thoughtfully, can be managed to minimize visual disruption to adjacent properties. You stagger the gate openings. You adjust flow rates for a slower, more gradual drop. There are established practices that dam operators use when surrounding properties have been developed and aesthetic concerns are a factor. I didn't apply any of them. I opened the primary gates to standard drawdown aperture and let the lake drop at its natural rate. By noon on the 14th, water level had dropped 14 inches. By 6 p.m., 2.9 feet. Patricia called that evening. The HOA's attorney had left her a voicemail. Several floating dock systems had experienced suction irregularities as the water dropped, and 2 had partially rotated on their anchor points. No structural damage, no injuries. She asked if the operation was proceeding per permit. I told her it was. There was a pause. Then she said, "Okay, Maggie." By morning, on the 15th, the lake had dropped 5.1 feet. A band of pale clay and exposed root systems appeared along the entire shoreline, soil that hadn't seen air since the dam was poured in 1953. The HOA's community boat ramp was sitting 8 feet from the water's edge. Several dock platforms had grounded on the shallow shelf. A news helicopter arrived around 10 a.m. One of the homeowners had posted footage to a local community Facebook group with the caption, "Our lake is being drained." The video reached 80,000 views in 12 hours. Pinnacle's attorneys filed an emergency motion with the Court of Appeals that afternoon. The court denied it by close of business, citing the trial court's explicit finding on operational authority. On September 16th, Charles Breck arrived, inspected the foundation, confirmed full structural integrity, and signed the inspection certification. Gate adjustments for refill began September 17th. Normal lake level restored by September 20th. No homes flooded, not close. I want to be exact about that, because there were reports that characterized what I did as deliberate destruction. I did not flood anyone's home. The lake dropped, legally, on schedule, with proper notice, for a legitimate and documented engineering purpose. But I also want to tell you something honestly. I was not unhappy about what it looked like from those docks, and I think you knew that already. The aftermath moved faster than anything in the previous 4 years. Pinnacle filed a supplemental appellate brief, arguing that my dam operation constituted bad faith conduct intended to damage HOA property values and requesting sanctions. Patricia's response remains, in my opinion, one of the finest pieces of legal writing I've ever read, and I've read a great many involuntarily. She entered every notice document, every permit filing, every court order. Charles Breck's inspection certification, the TDEC drawdown approval, and an expert declaration from a dam safety professor at Vanderbilt University confirming the operation was conducted within standard parameters for a structure of this class and this age. On February 23, 2023, the Tennessee Court of Appeals issued its ruling. Appeal denied. Trial court findings affirmed in their entirety. Riparian rights confirmed. HOA easement claims voided. Dam operational authority, exclusively and unambiguously, ours. The court also declined to impose sanctions, finding that the drawdown was consistent with the permit holder's established legal rights and professionally documented maintenance obligations. In April 2023, Pinnacle Shoreline Development, LLC, filed for Chapter 11 bankruptcy protection. The bankruptcy filings made for illuminating reading. The company had leveraged 94% of the Kettle Lake Shores development against a private equity credit facility. With the easement claim voided, the financial architecture of the entire development collapsed. The 97 homeowners kept their properties. Their homes, their lots, their deeds, those were valid. They were buyers in good faith from a development that had since failed. But the lake access that had been the centerpiece of the community's value proposition was now governed entirely by our permit. Late in 2023, the Kettle Lake HOA Board, now genuinely independent, representing real homeowners with real interests, came to Patricia to negotiate. We reached a limited access agreement. Recreational lake use for existing homeowners. No dock construction within 50 feet of the original shoreline boundary. No future commercial development. No expansion. And a one-time access licensing fee of $220,000, drawn from the HOA's reserve fund. It covered the last of our legal bills. I still live on the ranch. I wake before 5 most mornings. I drive the fence lines. I check the dam every week, the water gauges, the gate mechanisms, the overflow channels. I know every sound it makes when the rain has been heavy and the pressure is building against the concrete face. That knowledge lives in my hands the way my father's did, and his father's before him. But the shoreline isn't what it was. 18 acres of timber are gone. The hardwoods that lined the eastern bank when my grandmother named this lake, gone in 6 weeks of clearing equipment in the winter of 2018. And the great blue herons haven't come back to the eastern cove. On summer weekends, I can hear music from the vacation homes across the water, and children laughing, and the low thrum of boat engines turning across the surface of my grandfather's lake. I don't hate those families. I want to be clear about that. Most of them bought a dream, the same way Earl Caldwell bought 340 acres with $4,200 in borrowed money and a belief that the land would hold. They just didn't know the dream they were sold had been built on stolen ground. My father used to say that land doesn't lie. Deeds get fabricated, surveys get manipulated, lawyers build arguments from boilerplate, but the land itself, the silt line, the root depth, the water table, that tells the truth eventually. He was right. I won the permit. I won the rights. I recovered nearly all of the legal fees. What I didn't recover was the quiet, the particular silence of a lake in the morning that belongs entirely to itself and to your family and to no one else. That's the loss I couldn't put a dollar figure on. Whether it was worth it, whether some smarter version of me could have found a way to fight this that cost less in timber and birds and stillness. That's the question I'm still sitting with on the mornings I drive out to check the gates. That question is the one worth arguing about. Because what I did at those gates was legal. Whether it was right, whether I was a woman defending what her grandfather built, or a woman who made 97 families pay for the sin of a developer. I'll leave that for you to decide. Both things can be true at once. That's what makes it hard. If this story moved something in you, the part that understands that ordinary people shouldn't have to spend $487,000 defending land their grandfather paid $4,200 for, then share it. Tell someone. Because these fights are happening right now in every county in this country, on lakefronts and fence lines and rural roads where the surveyors have already been out twice this year. And if you want to hear more of them, you know where to find them. Subscribe to HOA Nightmares, we're not done yet,